Joining us now from Culver City, California, is Adam Winkler, law professor at the University of California, Los Angeles, and the author of Gunfight, A History of the Debate Over Gun Control. Mr. Winkler, I want to start with the idea, a narrow question, and then we're going to broaden out. Senator Feinstein said she could think of no law that would have stopped this massacre in Las Vegas. Is that the way it looks to you as well?
Well, it looks like that, although maybe Dianne Feinstein should take a little credit. She proposed to ban these bump fire stocks in 2012 and in 2013 with proposals that went nowhere in Congress. So perhaps these devices could have been taken off the market beforehand, although that probably would not have stopped the shooting itself, may have limited some of the damage.
Let's step back. We're focused, as we have to be, on the specifics of this event and on the details of now this possible piece of legislation. What questions aren't we asking? What's the larger context here that we should be thinking about as we think about these issues?
Well, I think what we should be thinking about is a little less about mass shootings. You know, they get all of the attention with regards to the gun violence problem, but constitute only a small fraction of the casualties every year. You know, gun violence takes 33,000 lives and about 100,000 gunshot victims every year. This is mostly as the result of suicide and criminal misuse of guns, far short of mass shootings. Mass shootings are a problem that are very difficult to solve, but we can make some headway lowering the daily death toll from ordinary gun violence.
In trying to do that, in addressing either mass shootings or the daily toll that you talk about, the clash between rights heats up quickly. Is there a smarter way to think about it? I mean, people get frustrated both by the rush to legislation and then on the other side, the fact that there is no legislation that passes. Give us your sense from history how this can be addressed in a way that might be a little more effective.
Well, one thing we need to recognize first and foremost is that the Second Amendment is not what's preventing us from having good and effective gun control laws. The Second Amendment's been part of our Constitution and our heritage for a long time and does protect an individual's right to have guns for personal protection. However, the courts have always held that gun control laws, short of disarmament, are constitutionally permissible. And indeed, the Supreme Court only read the Second Amendment to provide an individual rights authoritatively in 2008. Clearly, we had this gun problem in 2007 beforehand. So the answer is not repealing the Second Amendment, as some have called for. I don't think that's the right way to think about it. Historically, we've always had the right to bear arms, but we've also always had gun control. What's happened is we've lost that sense of balance, believing that we need to have either gun control or gun rights, but can't have them both.
In the case in which the Supreme Court found an individual right, Antonin Scalia is often quoted in that case saying that there are limits. Is this really for the courts, given that the politics on this is so frozen? Is this really something the Supreme Court needs to weigh in on, or that the courts need to weigh on to reach this balance that you're talking about?
Well, the courts won't reach the balance unless we do so. And why I say that because the courts can't propose new gun control laws, and they're not going to issue some kind of remedial order mandating Congress ban bump stocks. Congress has to take that initiative itself. And I feel many people are very disempowered in the gun debate today. They feel like nothing's going to change. But I really do think it is a matter of electoral politics, that the NRA is a very, very strong fighting force because there's a lot of single-issue pro-gun voters who support the NRA's candidates when they endorse them in primary and general elections. Gun control advocates who are frustrated probably need to focus a little bit more on mobilization, getting themselves more politically forceful so that they can combat the NRA and those single-issue pro-gun voters.
Let me get your ruling on the question of concealed carry reciprocity. You heard the two views. What's the legal read of this and the federal legislation that's being proposed in the Senate?
Well, there's two different kinds of national reciprocity legislation, and we should keep them separate. The NRA is proposing a law that would allow, say, a Utah resident to come to California on tourism, for vacation, or for business, and carry their gun in accordance with that permit. But there's also versions of reciprocity that have been proposed in Congress that would allow a California resident to get a permit in Utah by online without ever having going to Utah and then carrying the gun in California. That would completely undermine the self-determination and local control over concealed carry that states and cities have traditionally used. But so it depends on which version of reciprocity we're really talking about.
Which has a better shot legally, do you think?
Well, I think actually legally it's much stronger for the NRA to propose a law that allows a Utah resident to come to California. Congress has the power to regulate interstate commerce. I don't think there would be a significant Second Amendment problem with that. It's a little bit more challenging to say that as a matter of interstate commerce, Congress can mandate that California residents be able to get a permit somewhere else and carry those guns at home.
All right, Adam Winkler, thank you so much for being with us, and we'll be right back.